All right, under the rules of criminal procedure, the state of Texas may open and close final arguments. What says the state?
Your Honor, the state would waive its right to open, however, reserve its right to close.
You may. And Mr. Lewis, when you are ready.
Thank you, Judge. Good morning, everybody. This will be the last time I get to talk to you all about this case before you go to make your decision. Okay. I'm not going to take up too much of your time. I just want to kind of point a couple of things out to you. Now, you remember from the start, we talked about perception and reality, or is how sometimes people's perceptions can get merged into their reality. And we talked about that hypothetical car A hitting car B, and how, it takes the opportunity for whoever the trier of fact is to be able to hear everything and see everything in order to make their decision. Okay. So the first thing I want to definitely point out to you is that all the evidence that has been presented here and entered into evidence is available to you. So any of the videos or photographs that you would need to look at to help make your determination, you can look at. It'll be here for you. Okay. So let me go through a couple of things I want to point out to you. First thing is those red clothes, because it's been talked about how that he was in this red distinct warm-up sweatsuit and pointing that out. I will say, yes, if you look at the partial video from inside that store, yes, he is the only one in red. So it would look like that would be pretty unique, something pretty unique, especially to him, right? But look at the rest of the videos. You look at the video from across the street, will give you a full view of the neighborhood and people out and about. You're going to see about 2 or 3 people in red sweatshirt shirts and hoodies and sweatpants. So it's not that unique of a thing to wear the color red or be in a red sweatsuit. So that's definitely something for you all to keep in mind and consider. What's also really important for me to point out here, and it didn't really come up a lot in this trial, but it's definitely very important, is that we had a lot of talk about all the shell cases that were found out there, about where they were, how they were positioned. And you see a lot of that on from the body cam footage from the ID tech when they're putting the cones out and notifying where they all are. And they're talking about how when you see a cluster of them, that's indicative of where the shooter was or where someone was standing and shooting. And you'll see from the body cam footage, you'll see them pick up a wallet. That wallet is that Darren Daughtry person. And you actually see them look at the ID in the body cam footage. And when they take a look at that out and look at it, and so you're telling, the evidence that you're seeing from the physical evidence you're seeing is already telling you that there's a possibility of a shooter named Darren Daughtry among these cluster of bullets or shell cases. But that was never followed up on. It was never looked at who this person is, where this person is, what this person looks like, or any of that information. And that is not our responsibility. That's the responsibility of the investigating unit that's taking care of this case, right? So that was all we had from that. But we know that's always out there. We don't know. And then we get to the statements of Ms. Oakes and Mr. Bennett. The first statements we get from Mr. Bennett, of course, come from the 911 call. And you do hear him say in the 911 call, Trevonte Nichols. He does say my client's name. But then you also hear him say, somebody was shooting at me, which tells me that he's not clear about who it was that was actually out there shooting at him. So maybe it was just him recognizing him from school, or seeing someone from earlier, or seeing someone in a red sweatsuit and trying to make that connection. Like we talked about, perception versus reality, how he got to that point, right? So it may not be from actually seeing him do anything or knowing he did anything. We get to Ms. Oakes, and Ms. Oakes said here on stand that she saw Trevonte Nichols shooting at her or shooting at the car. That's the first time we've heard that in years. Detective Boudreaux, who did the investigation and did the interview with her, interviewed her and talked to her about everything that happened in the office. He talked to her about who was involved and who did this. At no time did she tell him that she saw Trevonte Nichols shooting at her or her child or her child's father at that time. So this is the first time we're hearing about this. Why now? Why now to come up here and say something like this? When Mr. Bennett here, of course, Mr. Bennett did not say that he did not make any testimony about Mr. Nichols shooting at him, or that he recognized him or saw him in the store that night, which that's clear to everybody. They were in the store that night together. And you see it that, and from the video, they're in there for, I won't say a significant amount of time, but enough time to where when they see each other, there's no issues, no problems, no argument, no staring up and down, nothing. And they both talked about their prior relationships before that night. There was no issue, no beefs, no. We don't know how we even get to this point. You have three decisions to make. First, let's talk about Messiah Ben. My client is charged with intentionally and knowingly firing that weapon.
No, it's
Oh, excuse me.
intentionally or knowingly.
Or knowingly firing that weapon. Of course, at Messiah Ben's. Thing we know here is that he did not intentionally or knowingly fire Messiah Ben. One, because either my client or even whoever was firing out there had no idea Messiah Ben was in that vehicle. So when it comes to making a decision in regards to Messiah Ben in regards to this charge, it will be not guilty. Same thing with Ms. Oaks. She testified she never got out of the car. Windows were tinted. There was no way for anyone to know there. So whether it was my client or whoever that may have been involved with this situation.
Your Honor, I'm sorry to interrupt his closing. However, I feel compelled to object because I think that's a misstatement of the law. I think the law says he just needs to intentionally or knowingly engage in the conduct. It's not a proper argument to say, well, he didn't know that person was in the car. The argument would be he intentionally or knowingly engaged in the conduct.
The instructions of law are provided to the jury from the court, and I trust this jury. They will follow the law as it has been stated when the law was given throughout the trial by the court and also in this jury charge. Go ahead.
No problem. Thank you, Judge. And that's what I asked you, of course, is to always go back to the evidence, whether it's the testimony or the videos or any photos. But when it comes to Ayanna Oaks, excuse me, it's the same thing. It's not guilty. He's not guilty of any aggravated assault when it comes to Ms. Oaks. And then we got Mr. Bennett, which is more questionable because you could say he did see him, he did know him, but there's nothing there that shows that the state has proven beyond a reasonable doubt that my client committed any aggravated assault against Philip Bennett. That burden of proof stays with the state. That's already been explained to you. That's been talked about in the jury charge. That's your obligation is to hold them to that. And when you look at all the evidence, totality of the circumstances, everything you get to see, I'm sure that you'll decide as well when it comes to Mr. Bennett, you're going to be able to find that my client is not guilty of that offense. Thank you, Richard.
State.
Mr. Lewis, ladies and gentlemen of the jury, there's always a concern with lawyers in opening statements of being too hyperbolic or overselling the case, making statements that the evidence does not live up to. And looking back, I submit to you, I believe my characterization of this scene and what occurred out there earlier as being indicative of something you see in a shootout or in a war zone. I think it was the evidence supported that. I mean, you've got these ungodly amount of number of shell casings and shots being fired. You've seen the video. The poor people at that gas station were ducking down for cover, fearing for their lives. And you see the bullet holes in these buildings, some of which went all the way into the last call liquor store, and the multiple rounds that went into that GMC pickup truck and into that Nissan. I don't feel like it was oversold to you, the seriousness and the dangerousness as it existed that night. What I would like to do, not unlike what Detective Boudreaux did, is just recap the evidence. And you've heard the evidence and the testimony in this case. You have seen those videos. They're in evidence, particularly that video that from the Valero that we've enlarged. Feel free to watch that if you want. And take a closer look at that. Take a look, if you choose to, about at the last call liquor store video surveillance video that shows the demeanor, the change in demeanor with regard to this defendant when Philip comes in. I think that's indicative or probative and important. Also, I'd ask that you use your common sense in evaluating the testimony. I mean, either you believe Ayanna Oates when she testifies that she saw Trevonte Nichols firing the shots, or you don't. You know, either you believe that 911 call that Philip Bennett made that you heard from the equipment there that it was Trevonte Nichols that fired at him. Either you believe him or you don't. I guess either you believe that the individual in that video or in all red left that store and drove away from that or left that parking lot and went on about his business, or either you believe that, or by some unfortuitous stroke of bad luck, someone moments after this defendant left that store dressed in all red, another individual came up dressed in all red and fired those shots at that vehicle as it drove away. We talked about this in jury selection about there being doubts and about there being reasonable doubts. And I'd ask you to use your common sense, you know, based on the testimony, based on that evidence, the video. Uh, uh, is it a reasonable doubt that only mere moments after this person dressed in all red leaves that liquor store, that somehow another person dressed in all red comes from behind or on the side of that store and fires those shots into that vehicle? I'll submit to you that it doesn't pass that test, that it is not common sense. Another thing I want to address is something that Mr. Lewis brought up, this whole notion about someone, the evidence must show that someone intentionally or knowingly knew that someone was in that vehicle. That's not my understanding of the law. You can read the jury charge yourself. It's a little splitting of the hairs. There's some minutia there, but here's my understanding of the law: that a person simply must intend or knowingly engage in the conduct that causes the result. Because think about it. If all the defendant has to do is to come in here and say, I didn't know that that baby or that person was in the car or in the building that I shot up or in the house that I shot up, and that would be a defense, then that's what each and every defendant would say in each and every case. I didn't know they were. So that's why my understanding of the law and my understanding of why the legislature worded the law that way is because intentionally or knowingly goes to the act, not to intentionally or knowingly having to prove that they knew that that person or persons were in the vehicle. The why or the beef or if, I mean, who knows why he did it? I mean, I don't have to prove whatever defect he may have, whatever malfunction may be going on. Who knows? Had a bad day, didn't like the way Philip Bennett was dressed that day. Who knows? It's not something I have to prove. Okay. All right. So I would submit to you not to get caught up on that. You've got the evidence before you. You heard the testimony from Detective Bujo that the shots that were fired by Philip Bennett were in self-defense. You watch that video, it is clear. This defendant is firing on that vehicle without being fired upon first. Thank you.
All right, this time, ladies and gentlemen, I'm going to tender the jury charge to the bailiff. I'm going to ask the 12 of you in the jury box to please follow the bailiff into the deliberation room. We will await your verdict or verdicts. All right, the 12 will follow the bailiff, and the alternates, please stay close by and we'll keep updating you. Thank you. The record shall show all parties are present and the jury is present in the courtroom. And Ms. Hicks, I understand you are the jury foreperson. We have received a message on behalf of the jury that the jury has reached a verdict in this case or cases. There are 3 cases before the jury. Is this so now?
Yes, sir.
Is this verdict or verdicts unanimous ones? That is, ones that are agreed upon by all members of the jury?
Yes, Your Honor.
And do any of the jurors disagree with your foreperson's representations? No disagreement is indicated. The verdict or verdicts do indeed appear to be unanimous. I'm going to ask you to please pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict or verdicts. All right, the court has reviewed the verdict or verdicts. The defendant shall rise. In cause number 24 CR 300, the state of Texas versus Trevonte Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. This verdict signed on behalf of the jury by the jury foreperson. In cause number 24 CR 301, In the state of Texas versus Trevonte Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, signed by the foreperson of the jury, and in cause number 24 CR 302. In the state of Texas versus Trevonte Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, and this verdict as well is signed by the jury foreperson. All three guilty verdicts in these cases are received, made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, at this time I have received and accepted your verdicts, finding the defendant guilty of the offenses of aggravated assault with a deadly weapon, second-degree felonies in each of these three indictments that were before you. That brings us to a close of phase one of the trial. We will now go to phase two, the punishment phase of the trial. And let me repeat once again, you are still under all the instructions that have been given to you before. Let me see the lawyers real quickly up here, please. Thank you. We're going to huddle for just a moment, ladies and gentlemen. All right, ladies and gentlemen of the jury, what we're going to do is take a break, about 10, 15 minutes, relax, stretch your legs, report back outside, and we will bring you in, and the parties have an opportunity to present any additional information they wish for you to consider for the purposes of punishment. All the evidence in the guilt or innocence phase is also something that the jury will consider by law, can consider by law in your deliberations, but the parties can supplement that information with other type of information so that you can make a most thorough decision in this case. So, and I understand that the presentation of both parties will be succinct. So we're going to try to get this presented. I'll have a set of jury instructions that are much shorter on the punishment phase. There are certain things that don't need to be duplicated. And then the lawyers, upon the presentation of the case and completion of evidence, I will read to you the jury charge. The lawyers will make their final arguments, and then you will go back to deliberate on a verdict or verdicts for the punishment phase. That's our plan. Okay, thank you. Everyone else remain seated while the jury exits first. All parties are ready, and the court is asking the bailiff to bring the jury forth for this punishment phase of this trial. We will hear evidence and then arguments. And the court will give its closing instructions. Record shall show all parties are present and the jury is present. As before, the state of Texas may open and close final arguments. What says the state?
The state would waive its right to open and reserve its right to close.
Mr. Lewis, when you're ready, sir, thank you.
Really sure.
And the law states that in final arguments, as in the guilt or innocence, lawyers have a reasonable amount of time to make their final arguments for the punishment phase. There's no definition of that. So, but these lawyers know the rules, and they're succinct. They're not going to waste your time. Go ahead.
Thank you, Judge. Good afternoon, everybody. Of course, this is the last time you'll hear from me as far as this case is concerned. And so the first thing I want to definitely do is thank you for your service of coming up here, serving on this jury, and definitely from the time it took you to deliberate, we can see that you were definitely focused and attentive and paying attention to all the evidence that you had. And we do definitely appreciate that. Now, I will say that my client has maintained his innocence throughout this entire situation. So it's a situation where, although we may not agree what that verdict was, we definitely respect it. We definitely want you to know that. Okay. Now, going forward, I'm not going to just come up here and beg you to give him a minimum or anything like that. I understand that, there's a punishment going to be assessed in this situation. Judge has already gone over the range of punishment. But what I want to talk to you about with Mr. Nichols, that it's obvious from the testimony of Mr. Robinson, Investigator Robinson, there that, this is a young man who's made some mistakes. Definitely made some mistakes young in life. As of right now, he's 24 years old, sitting here today. So there was definitely mistakes that he made when he was younger. And what happens when you make those mistakes young, it makes it a lot harder to navigate out of situations later on in life. And that's one of the situations that Mr. Nichols finds himself in. So my main concern or ask of you as jurors in this matter is when you considering that punishment, what that range is, what should be appropriate in this situation. I know we have to balance what happened out there that night, but we can't leave or not consider Mr. Nichols' life and his future. You know, we still want him to be able to because at some point he will be released, but we want him to be in a situation where he can be productive and positive and move forward for not only but himself but for his family, and also, of course, as a member productive citizen of our society that affects all of us. So that's what we really want him to be able to still move forward and grow from this in some kind of way, whatever that lesson may be. Hopefully, he's able to get it and sustain it and learn from it. Okay, and because at 24 years old, he's still very young, still very young. And you see from the testimony of Investigator Robinson, the other issues he's had, he was even younger than that. So these are things that he's been tackling, dealing with for a long time. And a lot of times, like I said, just be able to make the right decisions when you already have things or hurdles against you, or you have to get over, it makes it tougher and tougher. And this situation is going to be another part of it. But he's going to have to deal with it. Even in the situation where he does maintain his innocence in this situation, he still has to deal with the repercussions of this situation. So I'm not going to ask for a particular amount of years or number. I'm going to trust you that you're going to the same consideration you gave to come up with your verdict. You'll do that again in assessing this punishment and understand the goals of the punishment and hopefully what that final result can produce from that punishment. Thank you. Thanks, you.
State of Texas?
AFT support.
Yes.
Mr. Lewis. I want to begin by thanking you for your time and your the effort and that you put into your deliberations. And on behalf of Philip Bennett and on behalf of Messiah Bennett and I want to thank you for your very thorough in this case based on the evidence. A couple of housekeeping things before I get too far into my closing remarks. There was a mention of parole in your jury charge. I would encourage you to pay some attention to that because at the end of the day, whatever your verdict is, if you assess whatever punishment that you hand down, there is a possibility that this defendant will be eligible for parole after serving at least half of whatever your sentence is that you hand out. There is that possibility. You can consider that. You can't, and there's some specific language in that jury charge. You can't say for certain that he'll get it. You can't because to say for certain would mean that you know that what the parole board would do and you don't know that. But you can, the law says you can consider that there would be a possibility that after half of the time that you assess, he'll be eligible for parole. Another thing to consider in that charge, it talks about a fine of up to $10,000. I would submit to you, don't spend any time on that fine whatsoever. If it were somehow to get paid, it won't go to the victims in the case. It goes to the state of Texas and who knows what they do with that. So I would submit to you, don't spend any time on the fine. And lastly, as far as in the way of housekeeping matters, in these instances where there are multiple indictments coming out of the same criminal transaction, inevitably the first note that comes out from the jury when you go back to deliberating punishment is, will these sentences run concurrently or at the same time? And I represent to you that they will. So in other words, whatever you assess in the way of a punishment, it's not like they will get stacked on top of each other. They'll run at the same time. So with those housekeeping matters out of the way, let's talk about a concept that we talked about during jury selection, and that is mitigating evidence, something that you can consider that would mitigate toward the low end of the punishment range versus aggravating evidence, something you can consider that would aggravate toward or depart upward toward the high end of the punishment range. I submit to you that the fact that he had previously been on felony probation for theft of a firearm, and he didn't get the message, and he couldn't continue to commit his criminal ways, that's something that's aggravating that you should consider during your deliberations. I submit to you that even when he's on a felony probation, he goes out and commits the very same type of an offense that he's on trial for here today, an aggravated assault. A theft of a firearm. Why are you stealing a firearm anyway? And you are committing aggravated assaults. Mr. Lewis talked about making mistakes, and those mistakes making it hard to his words, navigate through life based on those mistakes. This is not criminal mischief. This is not some a DWI. These are serious offenses affecting the safety of and well-being of individuals, people. This defendant, for whatever reason, like I talked about in my closing argument in the guilty innocence phase, for whatever reason, there is something within this defendant that makes him violent, that makes him commit these types of offenses. And speaking of his violent propensity, the nature of this very offense is something you can consider. This very nature of this offense, the fact that we could be here on a very, very different type of a case. This would be a murder case. It didn't dawn on me because it wasn't mentioned in any of the offense report or material in my file that a projectile actually struck the back of Ayanna Hooks. It didn't dawn on me. And so I went back and I looked at State's Exhibit number 80, and there is a spent projectile in the back trunk of that vehicle. Here's a close-up, State's Exhibit number 81. There's a close-up of that projectile. By the grace of God, I guess maybe that the vehicle, the distance it had traveled, and whatever that projectile struck before hitting that truck, slowed it down before it struck the back seat of Ayanna Hooks. But think about that. And think about if you would have slowed down, and if it was just a little to the left, to the right, that poor baby inside could very well have been struck by that projectile. So again, his previous criminal history and the nature of his offense, I submit to you, mitigates toward the high end of the punishment range. He's fortunate that all he's facing is 20 years. I would submit to you that he is fortunate that all he is facing is 20 years. Look at these evidence markers marking all those charges. This is madness. And I was thinking about this morning. That very term came to mind. This is madness. And it reminds me of a line from a movie, and I don't often quote movies during my closing arguments, but there's a movie, you may have seen it, from 2006, 300. It's about the fictionalized battle between the Greeks and the Persians. And there's a line in that movie where the Persian messenger goes to that Spartan, the Greek king from Sparta, and he says, "This is madness." And that the response from the Spartan king is, "No, this is not madness. This is Sparta." And I submit to you that this is madness, and there are people in our community whose response would be, "This is Port Arthur." And it doesn't have to be there. We can change it. You can change it. It starts right here. You can end this madness. How? By sending a message with your verdict. You can send it with your verdict by saying, "You know what? This is what we think of this madness, and these are the types of sentences we're going to hand down." And if you think for a second that your sentences don't matter, here's what my experience is. And you talk to anybody in law enforcement, these guys will tell you, your verdict, when you hand it down, before you get on that elevator and get to the parking lot, it will make its way back to the jailhouse. Those defendants will know, because it's just how that works. They'll know that this is what you think. This is what you think of this kind of violence. This is what you think of this madness. Not only will the people in the jail know, but the folks on social media would know. The same very circle of people that this defendant runs around with. The same people who were out there that day. He wasn't the only one shooting. Those same people will know that you and I will no longer stand for this madness. This is not Port Arthur. This is not Jefferson County. I am asking you. I like Mr. Lewis. I'm not going to ask for a specific number. I like him will trust that you'll do the right thing, and you'll get it right because you got it right with the guilt and innocence. That's all I have. Thank you.
All right, ladies and gentlemen of the jury, at this time, I am tendering the jury charge for the punishment phase of this trial to the bailiff. Please step down from the jury box, follow the bailiff into the deliberation room, and we will await your verdict. We have a verdict on punishment in this case. We will be presenting the verdict here in a few minutes. Stand by. The record shall show that all parties are present and the jury is seated in the courtroom. Ms. Hicks, as jury foreperson, we have received a message from you on behalf of the jury that the jury has reached a decision in the punishment phase of these three cases. Is that true, ma'am?
Yes, Your Honor.
Is this verdict or verdicts unanimous decisions? That is, ones that are made up unanimously, all parties, all jurors present have agreed unanimous to these decisions.
Yes, Your Honor.
Any of the jurors disagree with your foreperson's representations? No disagreement. It does appear to indeed be unanimous. As before, if you would pass the documents to the bed, if you may be seated, ma'am. The court will review for proper form and publish the verdict or verdicts. And the defendant shall rise. In cause number 24, CR 300, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. In cause number 24 CR 301, all of these cases being the state of Texas versus Trevonte Nichols, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. And in 24 CR 302, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years. And that is another verdict signed by the jury foreperson. You may be seated. The court has received and made a part of the record the decisions and verdicts in this punishment phase made by the jury. At this time, ladies and gentlemen, the jury, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions. And at this time, I am releasing you from those instructions previously given to you. One final instruction is added. Once you are discharged, you are released from your oath of secrecy. You are free to discuss the case and your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a few minutes, the attorneys are going to be released after we do some formalities, and they always like to speak to jurors if you were willing to wait and talk to them. They like to get feedback. It helps them with their duties as lawyers, and they always find it rewarding to be able to speak with you to see what your feedback is and input for them to make them even better attorneys. But you're also free to go home or go about your business, but they will be discharged in a little bit. And again, you are free to discuss these matters with them as you choose or not. One final point. The flag that stands here not only stands for the United States of America with the state of Texas, but also it stands for the Constitution of the United States. We, the people, that's the way it begins. In order to form a more perfect union, establish justice. That's the very first part of how the Constitution begins. And jurors who come forth for jury service are right there in the first sentence of the Constitution. Your decisions determine what justice is. And a lot of people who are selected to come forward don't show up. They find other things they have to do. Sometimes they're good reasons, sometimes it's not. But in this county, we have a very great citizens for the most part who do show up for jury service. I want to thank you for your time and your attention. You're going to get a little stipend, but it's not enough financially to reward you for your important time. But whether it's serving in public office or serving to defend our country or serving to make the Constitution work, since a trial by jury is in the Bill of Rights. Without jurors, good citizens, we are unable for this country to work. And I want to thank you for doing your service and obligations as good citizens. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. Thank you very much.